You know, I felt so sorry for for Judge Glanville when he was taking advantage of from a prosecutor. I felt so sorry for this man. But now, your turn, Judge Whitaker. But I don't know if you're going to get away with you. Y'all remember this?
Your Honor, at some point, Your Honor, I'm sorry, I'm talking, and I don't know why I am being interrupted. I will not stop, Your Honor. I was speaking. I'm sorry, I was speaking. I know, I was speaking, and I expect you to allow me to speak when I'm speaking.
Both of you all need to just take it down a notch.
And so, Your Honor, if I may finish, because I was the one speaking before Mr. Weinstein interrupted.
But you continually engage in this pattern of behavior, Ms. Love. You don't want to accept my ruling.
Your Honor,
See? Pattern of behavior. All right, Judge Whitaker, you better look. Now she's taking it out on them kids.
I know you're being an advocate, but at some point, stop. Just stop. I made my ruling. Good, bad, or indifferent to you. You're going to win some, you're going to lose some.
I do accept that fact.
No, you don't. No, you don't.
She don't.
We have just not been able to present the evidence.
No, I get it. And if you have an independent basis to introduce statements that may not, or that may be not subject to the fruit of the poisonous tree, or any other thing, or any other issue related to evidence that may have flown out of this particular interview, then I'll hear it.
Listen to what the judge said. Whitaker, you need to go back and look at this. Glanville trying to tell y'all that they are just picking up evidence and placing it inside this case. There should be no reason why Moontoon should be locked up.
That point in time.
When the court says independent basis, does the court mean outside of that video? Because we do have that.
Yeah, if it's not tied to the statement, of course you can introduce it. I mean, as long as you have some independent basis, right? If you didn't get it from his particular statement.
But Your Honor, that's the point that we have the witness here, that we brought the witness here, and had him cancel medical appointments to testify to the court about. We brought the witness here.
I made a ruling. That has nothing to do with it. That's a red herring, and you know it.
No, Your Honor, I was saying that we were ready to present.
See, Miss Slicky, bye.
And the court is not allowing us to present the evidence. That's all that I'm saying. We have the burden of proof, and we haven't even been able to present the evidence that we have. We only, for the sake of ease, allow.
And how many times have y'all heard the prosecutor say that? She said that in Whitaker. Okay, now she having Miss Hilton to say it.
The court to introduce the statements that the defendant made as states 1 and 2 to help Mr. Weinstein play the portion that he wanted to talk about. We didn't even get a chance to play or to have the evidence that the state has ready for presentation to the court to be presented. We should be entitled to present the evidence so that the court actually has the circumstances and does not have speculation or conjecture as to what happened. When the court, the Georgia
She's
Supreme
still
Court
talking.
has clearly said, just as clearly as an attorney being present is required before you consider the statement once he's invoked, the court has as clearly said, if he reinitiates, then that statement can be considered. It does not use them like maybe. It says, if this or that, then the statement can be considered.
She's still going on. She's still running her mouth. And she's still disrespecting the judge. And judge, you don't have to listen to this.
Unless it should be suppressed for another reason. And that case, Paldo, is as recent as 4 years ago. And I'm not just doing this for the sake of engaging in a pattern of behavior, Your Honor. I am standing here emphatically asking that the court allow the state to present its evidence so that the court can make a ruling based on the evidence and not on the assertion by one party or the other as to what should or could be done. We have evidence that I believe
she's still talking.
The state is entitled to present, and the court is entitled to hear in the form of testimony. And I understand that Mr. Weinstein
she's still talking.
hurried along and not here to admission or evidence to his client's position. But we are simply asking that the court allow us the opportunity to present the evidence and to not hold it against this.
Miss Love, you are repeating yourself over and over. You and Judge, you still sitting here letting this woman repeat. She's going around in a circle. Something ain't right. That lady stop talking. That lady stop typing because you ain't doing nothing but repeating yourself over and over. Stop it, Your Honor. Stop her from talking.
State that I am asking this, that the court allow us to present evidence that this statement was made voluntarily, and that the fact that he ceased it but then reinitiated it.
She's still
is something
talking.
that the court should consider. And Your Honor, I don't like drawing the court's ire. You know,
She's still talking.
disturbing, but I cannot in good faith not present evidence when we have a whole burden of proof to show the court that it was made freely and voluntarily, and when the evidence that we have
And she's still talking.
And the court's whole purpose for having these hearings is to determine the truth.
She is still disrespecting you, Your Honor. That lady been talking for 5 minutes, and y'all letting her talk. This is what we're going through in this case right here, y'all.
Decide what is fair, and without hearing from Detective Thorpe, I don't know how the court can discern.
And then Detective Thornton don't even remember nothing. Detective Thornton doesn't remember anything. He don't even have his notes, his files. He can't even find
But the truth of the matter is, hearing only a portion of a recording and not hearing from the people who were actually standing there talking to and listening to the defendant. Unless, without hearing Detective Thorpe, the court is making a credibility judgment before even hearing what he has to say.
Still talking.
Please speak. Please. Mayor, please speak.
Your Honor,
Are you finished now?
I was not, Your Honor. I was not.
All right. The state has a motion to compel defendants' compliance with the reciprocal discovery obligations and to exclude evidence intentionally withheld and not timely disclosed. And I had via email asked specifically as to the authorship of this particular motion and to have whomever authored this motion be present in court. The response I got back was Ms. Love saying, I will be present. Does that mean, Ms. Love, that you are the author of this motion?
Yes, Judge.
Okay. So I have some problems with some of the representations made in this motion. Specifically on page 3, the citation to U.S. versus Young, and then to U.S. versus Waddell, and then the statement, quote, a defendant has a duty, underlined, to disclose prior to trial and an ongoing duty to timely disclose, in bold, any evidence he intends to use as both impeachment evidence and as substantive evidence of innocence.
And that's what she did to Moontoon. That's what she did to Moontoon. Y'all ain't paying attention.
Meaning see the above two cases, Waddell and Young. I've read both of those cases. Show me in either of those cases where there is a proposition that discovery and reciprocal discovery.
But she all quiet with Whitaker. But she was going back and forth with the judge, with Judge Glanville. But she ain't said nothing. She ain't cut the judge out or nothing. You see the difference in a person, a judge, a person, who she been around, who she haven't been around, doing what she want to do. She ain't arguing back and forth with the judge right here. This woman right here just like a cat.
Reciprocal discovery obligations of the defense applies to evidence that's going to be used solely as impeachment.
I didn't say solely as impeachment. I said as both impeachment and as substantive evidence.
Which
Yeah,
use of it as impeachment evidence triggers
that's
the
right.
reciprocal discovery obligation.
No, unless I wrote it inartfully. What I was
Well,
saying,
you wrote it in artfully.
I did then, because what I was saying,
Look, but you look. She didn't do Glanville like that. You said impeachment, huh? Impeachment is impeachment, regardless of the way you put it.
that it has to be both. That is the representation that
All right.
I made, and then when I amended it,
I didn't see an amendment.
I have a copy.
Did you fix that?
What I did was
Thank you.
Just put it together.
elaborate on it, or yes, I guess you could say it's
See? But y'all, the point is, she disrespect Judge Glanville, but she ain't disrespect this woman. Now she bumbling.
See then that if evidence is going to be used solely as impeachment evidence, that there's no triggering of a reciprocal discovery obligation?
yes, that's not, yes, I was not saying that. I was saying
Good to know.
my apologies to the court for that inartful wording.
My apology to the court with that. See this fakeness? Judge, if you, she's working some on you now. And she ain't gonna talk to you like she talked to Glanville. Wake up now. I still say Muntu not supposed to be locked up. I'm sorry.
And what I said in the amendment, Your Honor,
Amendment.
was,
Did you email the amendment to my chambers?
I did,
Okay.
yesterday.
Okay. Well, that may be why I hadn't seen it, although
Oh.
I'm looking at your stuff.
But you ain't going back and forth with her like you did Glanville. Oh, you were catfighting with Glanville. Now you a bullfighting. But you ain't doing nothing with her.
Oh, stop. Okay. Point. It's in front of me now. So
So what our position is, Your Honor, as I state on page 3 of the amendment, is outlining what Georgia's statutory requirements are. Of course, the court is aware what OCGA 1716 4C1 requires. And then I go down to subsection C on that same page where I cite Aggie versus the state.
pleasure. The court's exposition of that issue in the Waddell case.
And in that amendment, I did correct
All right.
what Waddell site.
Okay. All right. So we'll follow that law as well.
Is wrong. There is no distinction in Georgia on substantive or impeachment. What you were told is wrong, and this lawyer knows it because she sat here in court and I did the same thing without being tempered.
All right.
That's 4 times.
Woo.
Thank you for clarifying that. Any Georgia law that represents your motion?
No.
Your Honor, that's just it. I have been clear in my amended motion, and to the extent that it wasn't, yes.
Okay.
And also, I just want to say that,
No Georgia law that
right, Georgia law does not define.
She just lied. She just lied on Georgia. You see that? It's nothing saying nothing from Georgia. Well, thank you, Steele, Mr. Steele. Boy, Judge, you got hell on your hand. Now, so the state couldn't. So the prosecutor, the state couldn't. Prosecutor Love, the prosecutor, couldn't get the judge's attention. So she added on, how did Muntu probation violation come in this? I just talk to me about that. How did the probation violation come in this case?
Sections, I believe it's sections 4 and sections 5 of the plea agreement.
So also this in his probation? This called his probation to be violated? It is, y'all. See, I don't know. So they can for what he said under oath. I know it can get perjury, but what I'm saying though, probation. Oh, see, I don't know about probation, but this can happen. So we locking them up now for probation now. Oh Lord.
Signed that he again understood and reviewed each one of the acknowledgments that he initialed as part of the special conditions of his plea. That when called to testify, if called to testify, that the specific factual acknowledgments within the plea agreement were true and accurate statements, and that would be the testimony that he would provide as it relates to his witness testimony during the trial of this case. So I would present to the court State's Exhibits 1 and 2, as well as a USB drive of the defendant's testimony on day 124, 125, 126, and I think 127, Your Honor, but all of the defendant's testimony can be found.
Okay, this is the question I have to ask you all attorneys out there. Can you please explain to me how did his violating his probation has to do with this case, with this trial? So and another question I need, can you connect his probation with the trial? I mean, please explain that to me. Y'all like, share, and subscribe. I'm out of here.